Under California Unemployment Insurance Code, an employee who resigns, an employee who voluntarily quits his job is not eligible for unemployment benefits unless he resigned for quote-unquote good cause. The term good cause is defined as substantial and objectively compelling reason for resignation. That reason cannot be something as trivial and common as having conflicts or disagreements with your coworkers or with your boss, or not being paid as much as you think you should be paid, or not getting that promotion when you thought it would be fair for you to get it, or getting some kind of unfair performance evaluation or performance review. It has to be more than that. It has to be objectively compelling reason. Objectively compelling means that any other reasonable person in your place would feel like they have no other alternative except resigning. And generally there are three common situations that qualify as good cause within the meaning of Unemployment Insurance Code. The first common situation is when your company relocates far away, which makes it impossible or non-feasible for you to get to work every day. Let's say you've been working at this location, they decided to close it, and then they opened a new location 200 miles away, 300 miles away. And you don't have a choice. You can't work from home, even though you ask for it. There's no other solutions. Either you relocate closer or you drive 4 hours each way. This is a good cause for resignation, especially if you have other circumstances which make it impossible for you to relocate, such as having a family or having children in school and so forth. Every small fact that suggests that it would be impossible for you or extremely challenging for you to accept that new condition of working at that new location would be very helpful. The second common situation that qualifies as good cause is substantial reduction in pay. Maybe a demotion where you would be paid 30% or more less in your compensation that you've been receiving so far. And the third common situation is where you are subjected to egregious harassment. And that could be violence at work or threats of violence, pervasive racial harassment, maybe racial slurs that the employer failed to do anything about preventing and remedying despite your complaints. Maybe it's failure to accommodate your disability. Maybe you have certain restrictions that the employer refuses to honor, and so forth. So, any extreme situation at work that involves discrimination or harassment would also qualify as good cause. In any event, before you quit, it's a really good idea to run your situation and your plan to resign by an experienced employment attorney if you really care about being eligible for unemployment benefits. While no attorney can guarantee that you will qualify for unemployment benefits and that your situation will be considered as good cause within the eyes of the EDD, they can assess and they can give you a very good idea of what your chances are to receive unemployment benefits if you resign under your specific situation. It's much better than being denied unemployment benefits and then going to an attorney and asking him what you can do about reversing that denial and appealing it and getting benefits. It's much easier to prevent the problem than trying to fix it later. Thank you.